Morena tātou. Thanks so much for joining Responsible Lending, our Responsible Lending session. We'll just give everyone a moment or two to get logged on. Good morning, everyone. You are joining our Responsible Lending session, and we'll just give everyone a moment or two to get their Zoom sorted and join the webinar. Tēnā koutou katoa, ngā mihi nui kia koutou katoa. Nau mai, haere mai. It's my pleasure to welcome you to the second of our 4 in-depth focus sessions on the changes to our credit laws. Now, I'm aware that some of you will have watched our first seminar on disclosure and advertising with Crystal Uden, so I'll apologise in advance for any repetition of the outline of the session and our housekeeping. Now, if you missed it, don't worry, we have recorded it, as we will record this one and our others, and we'll make them all available to you. So many of you will have attended the overview seminar a couple of weeks ago, and if you want to see a high-level summary of the Commission discussing the 5 main areas that are changing, and a bit about the education and enforcement approach of the Commission, the link's about to pop up in the chat. We also made a series of informative kind of handouts, really detailed handouts, going through the main changes that are underway. There's 5 of these. And if you haven't received them, you can email us, or they're available on our website. And again, Penny's going to pop a link in the chat for you. Now, thank you so much to all of you who took the time to fill in the surveys at the end of the seminar and give us your questions. They were really thoughtful, and they helped make sure that we're guiding these in-depth sessions to give you the information that you want to hear. I can see someone's just popped a question in the chat that if their question about disclosure or advertising from the last session wasn't able to be covered in our session, there was a survey at the end of that, and you can pop your questions in there. Or of course, when this one closes, there's a survey where you can put more questions and we'll get those answers out to you. So as you know, today's session, the one we're in right now, focuses on responsible lending, and our expert, Mark Atwell, will be addressing some of your questions and answering your questions live as they come through. But before we get started, I'll open with karakia. Whakataka te hau ki te uru, whakataka te hau ki te taonga, ke mā kena ke uta, ke mā taratara ki tai. E hia ki ana ti atakura, he tio, he hoka, he hauhonga, ti hei mauri ora. Now, before inviting Mark to speak with you all, I'll quickly go over some housekeeping. If you've got a technical issue, raise your virtual hand. It's under the reactions on the bottom of your screen, and we will see if we can assist you in the chat function. You can also use the chat function to ask those questions so that we can answer them live if we can, or get to them later on in the session. We'll keep a watch on those, and as they come up, we'll know if we know we're going to be talking about it later and we're going to get to it. Otherwise, we'll answer as we go through. Now, Penny, hi, she's handling our Zoom, and I'd like to introduce her now. Welcome, Penny, and thanks so much for helping us out.
Kia ora, Sonia, and kia ora koutou. I'll be handling the chat function today and putting through any of your questions to Mark. You can pop these in the chat function or note them in the survey or email them to the Commerce Commission after the webinar. Kia ora.
Thanks, Penny. Thanks so much. Right, let's get on with it. Mark Atwell is a principal advisor at the Commission. He's an expert with a significant amount of knowledge and experience, so he can give us lots of information about the changes. When it comes to responsible lending, there's a really large amount of facts and lots of details to consider. So we're going to record this session as we have with all of our sessions so that you can refer back to it. We're also going to put links in the chat so that you can read the code and the guidance and the legislation that Mark's referring to at a later date. The session's supposed to run for an hour, and if you get to the end and you've got more questions, like I was saying, there's a survey at the end where you can put those through. But now I'd like to welcome Mark Atwell to discuss responsible lending with us. Kia ora, Mark.
Kia ora, Sonia. Thanks, Sonia. So as noted by Sonia, my name is Mark Atwell, and I'm a Principal Advisor in the Credit Branch at the Commission. So in this webinar, I'll briefly summarise what was covered at the earlier session in relation to the upcoming changes to responsible lending obligations. And I'll try to answer some questions that consumer advisors have put to us at the online webinar earlier this month. We received a lot of questions in relation to the responsible lending changes. So we appreciate this is an area that's of concern to consumer advisors, especially financial mentors who are advocating for clients and working closely with lenders. So while I'll endeavour to cover as many questions as possible, don't be offended if I don't cover your question today. There are, as I said, a large number of questions, and our aim is to cover the questions that seem to be causing most concern. And it might also be worth mentioning that we did a similar deep dive for lenders, and this responsible lending was by far the most topic that was of keen interest, and we received lots of questions about the upcoming changes to assessing suitability and affordability. So the lenders are quite keen to get this right.
Yeah, they really are, Mark, aren't they? We had hundreds of lenders attend our responsible lending seminar, which is fantastic. And we did also receive many questions, and a lot of them covering similar themes. But Mark, perhaps before you talk about the changes to the law, it might be useful to set out quickly what lenders' obligations are currently.
Okay, so as we know, lenders are required to comply with the lender responsibility principles in Section 9C of the Credit Contracts and Consumer Finance Act. So lenders are creditors under consumer credit contracts, so it's non-business lending. And mobile traders, as defined in the Act, are also treated as lenders. And the overriding principle is that lenders must at all times act with the care, diligence and skill of a responsible lender in their advertising, before entering into a loan or insurance contract or guarantee, and in their subsequent dealings with the borrower, guarantor, or in relation to that financed insurance. Lenders must also comply with the lender responsibilities, again in Section 9C. So these include to make reasonable inquiries before entering into a loan. So it's to be satisfied that it's likely that the loan will meet the borrower's requirements and objectives, i.e. that the loan is going to be suitable, and also that it's likely that the borrower will be able to make the payments under the loan without suffering substantial hardship, i.e. that the loan's affordable. So I think it always pays reminding that when we talk about suitability, we just mean assessing for an appropriate product to meet the borrower's needs. It's not about the lender making a judgment on what the borrower wants to spend the money on. And the Responsible Lending Code provides guidance about how lenders can go about complying with their responsible lending obligations. The code itself is not law, but the Act says that evidence of compliance with the provisions in the code is to be treated as evidence of compliance with the law.
Thanks, Mark. I wonder if you could recap the main responsible lending changes for us.
Well, I think there are three of them, and they take effect on 1 December 2021. They were going to take effect on 1 October, but in view of the current COVID-19 lockdowns, the government announced a delay in the implementation until 1 December. This gives lenders more time to make the necessary changes and to their systems and processes and to staff training. So the three key changes are, first, as well as making suitability and affordability inquiries before entering into a loan, lenders will also now need to make those same inquiries before making what's called a material change to a loan. This is also known as a top-up. So the term material change is defined, and it covers increases to the credit limit, or where the lender's looking to advance additional monies that they didn't take into account when they first did their assessment. Secondly, lenders will need to take specific steps set out in the regulations to assess for affordability and suitability. And I'll talk about this in the Q&A session, and that's mostly what the Q&A session will focus on. And finally, lenders will be required to keep records of the inquiries that demonstrate how they've satisfied that the loan was suitable and affordable, including the inquiries they made and what they found. And they'll need to keep those records for 7 years. And importantly, borrowers can ask for a copy of those records, as can the Commission, as can a approved dispute resolution scheme. And if a lender is asked to provide a copy, they must do so within 20 working days. So if you're acting as the borrower's representative with a suitable privacy waiver, you will also be able to ask for a copy of these records. So I think the 3 key changes that will be popped in the chat there. So as I mentioned, the Responsible Lending Code that provides guidance, that's also been updated to deal with these new changes and sort of gives lenders assistance about how they can comply. So the updated codes also comes into force on 1 December, except for Chapter 5, which deals with lenders' obligations when the borrower is suffering repayment difficulties, and that comes into force from 1 February next year. Again, I think we will look to place a link in the chat to that updated February 21 code.
Yeah, it's just popped in there now. Thanks for that, Penny. Hey, so Mark, what can you tell us about the suitability assessments?
So, it's quite a big change. So from 1 December, under the new regulations, they'll set out the minimum requirements for inquiries and assessments. So what's in the regulations is law, and if a lender fails to comply with the regulations, it will be a breach of the principles. So currently, these new rules are set out in the Credit Contracts and Consumer Finance Lender Inquiries into Suitability and Affordability Amendment Regulations 2020. It's a mouthful and a half, but from 1 December, it will all be incorporated into the normal CCCFA regulations. So I think we'll place a link to the amendment regulations in the chat. So the regulations are going to require that lenders make inquiries to determine certain sort of listed aspects of a borrower's requirements and objectives. So they'll need to find out, there's a big long list, but they'll need to find out and assess, amongst other things, the amount of credit that the borrower wants or needs, the purpose of the loan, the term of loan, and a number of other things. And then once the lender has obtained that information, and realistically it will need to be from the borrower, they then need to make an assessment about whether the loan that they're offering is going to meet the needs of the borrower. So remember, it's not about what the borrower does with the money, it's just about whether the loan is going to meet the needs of the borrower.
Yeah, that suitability factor. Hey, so I can see we've had a number of extra people join on since we started. I'll just remind people that you can pop your questions in the chat, that we are recording this, and that the links in the chat will also stay on when you watch it later, so that you can refer to the things that Mark's talking about, like the code and the legislation. We've also produced handouts, and they've got really good detail on them, and they're also available on our website. Hey, so we had a question about whether lenders need to ask enough questions to uncover things like benefit fraud. One mentor was concerned that if the loans were approved in these circumstances, that the income could stop, but the loan payment obligation would still be there. So Mark, do you want to talk to us a little bit about how far do lenders need to go with their inquiries?
Well, this particular question is a bit of a tricky one, but I mean, inquiry is not a defined term under the Act or in the regulations, but the Act says that the inquiries need to be reasonable. So it needs to be enough to gather the information that you need to comply with the law, but they shouldn't be so detailed that they become unreasonable for either the lender or the borrower. So I think in our view, inquiry includes asking questions or other ways seeking information or documents from the borrower or other third party, and then considering and analysing the information or the documents provided. So if benefit fraud became obvious or was suspected during the lender standard inquiries, we would expect the lender to act with the care, diligence and skill in that circumstance and be aware of the implications that could have on future income.
Yeah. So what about the level of record keeping that's required for suitability assessments? We had some questions about what should be expected of lenders when third parties like brokers or car dealers are the ones collecting and assessing the information. How does that work?
Well, the legal obligation to ensure that it's likely that the loan is suitable remains with the lender and not any third-party broker or intermediary either acting on behalf of the borrower or the lender. So the lenders need to keep records about the inquiries they've made under Section 9C, and they must demonstrate how they've satisfied themselves that the loan was likely to meet the borrower's requirements and objectives. Now, I think helpfully, the revised code does contain quite extensive guidance around the detail of record keeping for suitability assessments at paragraphs 4.14 to 4.16, and encourage you to have a look at these, but we'll also look to place a copy in the chat.
Yeah, Penny's just popped that in there now. I can see lots of really good questions coming through the chat function. Thank you. Keep them coming. We will talk about buy now, pay later later on in the session, because we've had lots of questions about that, both from lenders and also from you. So Mark, as we have had throughout these sessions, we've got questions about mobile traders. So do you want to talk to us a little bit about what they need to be doing, and what does this look like practically for mobile traders?
Well, I mean, I think it's essentially all the mobile traders that come under the Act will have all the same obligations as any other lender, including the responsible lending, suitability and affordability assessment obligations. So mobile traders will be caught by the Act if either they're a creditor under a consumer credit contract, or if they fall within the definition of mobile trader in the Act, which is essentially business who supplies goods to consumers outside of fixed premises and on instalment payment terms. So the Act treats those contracts as if they were consumer credit contracts, even though they may not meet the strict definition. So I think importantly, in terms of suitability, one key piece of information that mobile traders will need to find out as part of their suitability assessment is when the borrower wants delivery of the product. So I mean, if the agreement is a credit sale and the product delivery is going to be after 20 working days of the contract, then you have to ask the customer when they want the money. Also, I think practically speaking, the loan approval process after 1 December is going to take more time, and there's going to be more documentation than borrowers are previously used to. This doesn't just apply to mobile traders. So, and how lenders decide to process this is up to them. But due diligence duties require that their processes ensure compliance with the CCCFA. So yeah. I think we've also, in terms of mobile traders, we've also, in May last year, we developed guidance in our May 2020 guidance, and I think Penny will look to pop a link in the chat.
That's just gone in there. Hey, Mark, there's a question about add-on insurance products. I wonder, do you want to talk to us a little bit about how suitability should be determined for add-on insurance products?
Okay, so the regulation set out the minimum requirements for assessing suitability of repayment waivers, extended warranties financed under the agreement, or what's called relevant insurance contracts. So I think under the regulation, the reasonable inquiries must include inquiries into all of the following. So whether the borrower has existing cover for the add-on, or existing rights under the Consumer Guarantees Act that might protect them against some of the risks for which they're looking to cover. Whether the borrower's employment status or residency or age might make them ineligible to claim some or all of the benefits of the proposed product. I mean, that's been a problem for some of these products in the past. And then the benefit or cover that the borrower requires, and also whether the borrower is happy with the cost of the add-on product. So once the lender, and that's the minimum, but so once lenders have obtained that information, they then need to make an assessment about whether the product is going to meet the borrower's requirements and objectives, be a standalone product or part of the loan agreement. So again, in Chapter 9 of the Responsible Lending Code, the updated one, there's guidance around responsible lending obligations in relation to credit-related insurance, repayment waivers, and extended warranties.
That's great, Mark. Thank you. I wonder if we should move on to affordability assessments. We've talked a lot about suitability. What about affordability? So from 1 December, as part of the obligation to make reasonable inquiries to be satisfied that it's likely that the borrower can afford to make the payments on the loan without suffering substantial hardship, lenders must comply with the minimum requirements for inquiries and assessments as set out in Regulation 4AE to 4AO. So try not to talk about too many regulations, but they're all difficult letters. So these regulations are the law, as I mentioned earlier, and if you fail to comply with these, it'll be a breach of the responsible lending principles. So that's different from the code. So while some of the numbers and the regulations are complicated, you know, and acknowledging that assessing affordability is super complex, there's a really good flowchart in the Responsible Lending Code. Do you want to tell us a little bit more about that?
Yes. Okay. So Chapter 5 of the revised Responsible Lending Code at page 25, it contains a diagram which might help you, at least initially, understand how you should be thinking about affordability assessments. So that the diagram itself isn't the law, so it's really only a heads up for illustrative purposes, and it doesn't represent every legal step or test in the regulations, but it gives a nice idea of the sort of rabbit warren and complexities involved with some of these assessments. So the regulations require that lenders make reasonable inquiries to enable the lender to estimate over the relevant period the borrower's likely income and their likely relevant expenses. So the term relevant period refers to the time frame lenders need to consider when looking at income and expenses. So this is the relevant period, and it's 1 year from the start of the likely start of the loan, or less if the term is less than a year. So in other words, lenders will need to assess income and expenses for a 12-month period at the most, although that assessment must include expenses that are occurring during the relevant period, e.g. rates, but even if they fall due to be paid outside of it. So then I suppose the key test under the new rules is that the regulations require that the lender must be satisfied on reasonable grounds that it's likely that the borrower can make the payments without suffering substantial hardship because their likely income exceeds their likely relevant expenses, and one or more of the following applies. So there's either a reasonable surplus and or there are reasonable buffers or adjustments included in the income and or expenses. And this means that lenders cannot lend if their inquiries into a borrower's income and expenses show that they're in a cash flow deficit.
I know a lot of people will be thinking, you know, what does reasonable surplus mean? What does, you know, a reasonable buffer mean? Mark, do you want to talk a little bit about how the Commission is going to determine what reasonable means?
I mean, that's a good question. So, I mean, the regulations just say that the buffer or surplus must be adequate to address the risk, that the likely income may be overestimated, or that the expenses have been underestimated, or that there are other expenses that just sort of pop up. So, yeah, the terms reasonable buffer and adjustments and reasonable surplus, they're not defined in the regulations. The Responsible Lending Code does contain some guidance at paragraphs 5.8 to 5.10 about how lenders should assess the adequacy of the buffers and surpluses. In particular, at 5.10, it says that, well, the amount of the surplus buffer adjustment is not prescribed. It must be adequate to address the risk. What's adequate will depend on the nature of the credit and the risk that income's been overstated or understated. So it says, for example, a buffer or adjustment may depend on the size, term, or revolving nature of the credit product, and it can be a percentage or an absolute amount. As I say, it's because there's no definition, so I think we'll just have to wait and see to an extent. But in terms of what the Commission does and what we look at, what's reasonable, we'll just have to be guided by what the regulations say and what the code says.
Yeah, I can see that that's kind of how it's going to have to be. Hey, so we had a really good question come through from a lender that I think people will be interested to hear of, which is about an uncommitted monthly income, or UMI. And we thought this would be of interest, especially to our financial mentors. So the lender asked if there was a minimum UMI that the Commission expects to see. And they gave an example of a pensioner who's likely to have a much lower uncommitted monthly income, but maybe more used to managing their monthly expenses and their budget. What do you think?
I mean, this was similar to the previous question, I suppose, and about what is a reasonable surplus. So a minimum uncommitted monthly income is not prescribed as a dollar figure, but as mentioned before, so chapter 5 of the code just gives some guidance. Particular 5.8 at 5.9 just says lenders should seek to have a consistent set of buffers or surpluses or adjustments across the credit products that the lender offers. But but then it goes on to say that they can offer different surpluses or buffers or adjustments depending on the different risks of those products. So it says that a lender may have a different uncommitted monthly income requirement for a lower risk loan compared to a higher risk loan. So.
Okay, that's great. Hey, so there's a question that we've received, which says, do lenders need to ask for an employment contract when they're wondering about a consumer's income? So if that, a customer's income. So if the lender is asking about a customer's income, do they need to ask for the employment contract, or is 3 months bank statements or 3 months pay slips okay?
So the regulations provide that where a lender is estimating the borrower's likely income based on asking the borrower about the source of their income, they must verify that income based on reliable evidence, or if verification's not reasonably practical, consider whether the source and the amount of the income are realistic. So we would expect that in most circumstances, 3 months of bank statements or 3 months of pay slips should be sufficiently reliable evidence to assess income, or verify income, yeah.
What about seasonal workers? How should lenders approach assessments for seasonal workers whose hours may be cut, maybe after the assessment?
Well, the code suggests that lenders should consider adjusting volatile, irregular, or variable income, for example, by discounting the seasonal income bonuses, overtimes, or rental income or investment returns.
Hey, there's a complex question that's come through from some of our lenders, again, that we think people will be interested in, which is the lenders asked, how do they avoid unintended consequences of affordability assessments, such as discriminating against elderly people? Or one example we received was a pregnant woman.
Yeah, we're starting to get this question a bit, but the commentary in chapter 2 of the code provides guidance around discrimination on discrimination and compliance with the Human Rights Act 1993. So, I mean, as set out there, the lenders must, in the guidance, that lenders must not refuse to lend or apply different rules or principles to borrowers simply because of their age, pregnancy, or other protected characteristics. And at the same time, factors that have the potential to affect the borrower's future income and expenses will be relevant in a lender's assessment of whether a particular borrower can likely make the payments on the loan without substantial hardship. So I think as part of assessing the borrower's likely income, the regulations specifically require that lenders must ask the borrower about any likely changes in income. So I think this will provide an opportunity for lenders to discuss with the borrower potential retirement during the loan term, and how, for example, how are they going to have the income to meet the loan payments, or do they intend to sell assets, as well as any sort of known issues around likely anticipated childcare obligations and the effect that might have on borrowers' income and expenses.
Yeah. Hey, so there's a really interesting question come through about how lenders should verify whether a customer has other loans when this isn't necessarily captured on a credit report. So can lenders rely on the information provided by the borrower? Well,
lenders are no longer able to rely solely, rely on what the borrower tells them. However, in the regulations, gathering information by asking questions of the borrower is one of the ways lenders can use to gather the information from their assessment. So as part of making an initial assessment of the borrower's relevant expenses, the lender has to check whether there have been any expenses missed. So for new loans, this means they must obtain a credit report. And where the credit report shows debts which were not disclosed by the loan applicant, we would expect lenders to make further inquiry with the borrower about these. And where the lenders obtain 90 days of bank transaction records, which most lenders will need to for new loans, as part of the sort of what we call the second stage, where you're verifying and adjusting the expenses, those records may show loan payments which weren't disclosed by the borrower. So generally, taking these steps should allow a lender to verify other loans that the borrower may have. In rare cases, if there's an inconsistency between what the borrower had told you and what you can find in credit reports and bank statements, lenders may need to, with the borrower's consent, make inquiries of other loan providers. So in short, the lender has to do some cross-checking.
And that's a good thing. Hey, so financial rentals have said to us in the survey questions that we got at the end of the last session that they often see lenders failing to properly account for expenses, or entire categories of expenses are missed. What are the rules for calculating expenses now?
Well, I sort of mentioned this a bit already, but from 1 December 2021 this year, lenders must follow a two-part process for calculating the likely relevant expenses. So they must make an initial estimate from asking questions or obtaining reliable information, and then assessing that for missed expenses or missed loans. So, for example, health issues are revealed because the borrower receives a disability allowance, but expenses were missed from the initial inquiries. And in the second stage, lenders must verify the expenses with reliable evidence, and if necessary, adjust those expenses to reflect a reasonable minimum cost if the lender thinks they may have been underestimated. If verification is not practical and the lender is using benchmarks, then the lender must use the higher of the benchmark expense and the borrower's self-declared expenses. And also, when lenders are thinking about expenses, they must account for expenses or include expenses that borrowers are unwilling or unable to give up, for example, savings, tithing, or entertainment expenses. So specifically, to answer the question specifically, the regulations will now, they list what they call listed outgoings. And that's a defined term, which we'll look to place in the chat. And it includes fixed financial commitments, payments on any debts, living expenses, and then importantly, any regular or frequently recurring outgoings, for example, savings, investments, gym memberships, entertainment costs, or tithing, that are material to the estimate of relevant expenses. So would imagine for most loan applications now, you'll expect to see expenses divided up at least into those headings.
Yeah, so Penny's popping that in the chat now. And I know people will be really interested to hear about expenses that borrowers are unable or unwilling to stop.
Yeah, so I suppose that these need to be included as part of the expense calculation. I mean, some borrowers might have discretionary spending that can be adjusted if necessary. For example, recurring entertainment costs, e.g. if they're eating out, or alcohol or movie tickets. So you probably can just adjust some of those expenses downwards, provided that the borrower has confirmed that they're happy to reduce those expenses, and that the lender that basically that, and the fact that those, but if a lender is going to reduce some of those expenses, say on eating out or entertainment, then they must be still satisfied there's been sufficient spend calculated for in the general household expenses. So you might be able to reduce your takeaways, but as long as your food's going up, or there's going to be your food's going up, but perhaps not by as much.
Yeah, a corresponding, it needs to be taken into account, doesn't it?
So I think, I mean, it is quite tricky to talk through the regulations because they are very specific, but I think, as you can see, that the new assessment process is going to be heavily dependent on the circumstances and the individual financial circumstances of an individual borrower. And where lenders make budgetary adjustments to discretionary expenses, this is going to need to be done in consultation with the borrower, unless they're going up.
Yes. So we've got lots of questions coming through about that kind of the discretionary spend, and acknowledging that a huge portion of the population lives week to week, and the fact that they have no money left at the end of the week doesn't necessarily mean they can't afford to get a loan, but what it does mean is that perhaps some of their discretionary spending may have to go down.
Yeah, I think we're sort of just saying the same thing in a slightly different way. So lenders must work with the borrowers to determine the outgoings that they are willing and able to reduce, or they may work, rather, they don't have to. However, if the lender is going to reduce expenses, they have to have verified that they've come from the borrower's discretionary spend. So relevant expenses are defined in Regulation 4AE, and those relevant expenses can't be reduced. So it's only the discretionary expenses that can be reduced. And as mentioned earlier, the lenders must ensure that there's sufficient buffer or surplus And they also must consider, as I said, whether the relevant expenses are at a level that meets the reasonable minimum cost of living for a person in similar circumstances to those of the borrower.
So how do you define regular expenses? How do you group them? For example, how do you think the lenders and then, of course, our financial mentors are going to be thinking about how we approach recurring entertainment expenses?
Well, the regular expenses, as sort of set out in the regulations, are defined as any regular or frequently recurring outgoings, for example, savings, investments, gym memberships, entertainment costs, or tithing, that are material to the estimate of the relevant expenses and the borrower is unable or unwilling to cease after the agreement's entered into or materially changed. So these are separate to, in addition to the fixed financial commitments, the payments of the debts, and the living expenses, which must be first assessed. And I think the examples given in the regulation for AED provide an example of the types of expenses to be considered and how they should be grouped. So in estimating the relevant expenses, lenders should be asking the borrower about any recurring expenses or activities, including entertainment, to determine the amount that's spent on a weekly or monthly basis, and then the extent to which the borrower is willing or able to reduce these after the loan. Again, if at the verification statements, bank statements show higher, regular, or frequently recurring entertainment expenses, lenders would need to make further inquiries and/or adjustments with the borrower. Benchmarks can also assist if they contain a component or allowance for entertainment expenditure, for example, the household expenditure benchmark, or HEB.
Yeah. So there's a question that's come through that I think's really relevant about how does a lender determine if an expense is material to the estimate and needs to be included in the calculation?
Again, this is a bit of a tricky one. So the regulations only require, when considering regular recurring outgoings as relevant expenses, if it's material, meaning that I suppose immaterial or generally minimal outgoings don't need to be captured. So it's not yet known how lenders are going to apply this, practically speaking, and what they might consider to be immaterial. Given this, we've suggested to lenders that they adopt a relatively conservative approach by, for example, by taking into account whether the outgoing is significant in dollar terms, or even if it's low in dollar terms, whether the outgoing is significant due to its frequency, or whether the outgoing is significant due to its importance, how likely it is that the borrower is going to give up that expense.
So making those estimates is really, really complicated. I think, one of the financial mentors has asked, when lenders are making further inquiries about a customer's stated expenses, what would you consider to be an acceptable method? So what are the acceptable methods of making further inquiries regarding a customer's stated expenses?
I mean, I suppose our thinking would be that lenders could make reasonable inquiries directly of the borrower, either verbally or in writing, requesting that borrowers provide additional information or documents, e.g. bank transaction data or contracts or invoices. Lenders could also make inquiries of third parties as long as they've got the consent of the borrower, e.g. around credit checks or entities that the borrower might be making payments to. And I think further inquiries also includes comparing the information that you've got with benchmark expenses. So, I mean, the regulations require that, again, I think we mentioned this before, but consider whether the relevant expenses are at a level that would be below a reasonable minimum cost of living for a person in similar circumstances to those of the borrower. And if so, lenders need to increase that expense to be a reasonable minimum cost.
Hey, so there's lots of questions coming in about benchmarks. And one of them that I think is useful asks, when can lenders use benchmarks? And will the Commission provide more prescriptive benchmarks for calculating affordability and living expenses and things like that?
The regulations say that an expense is a benchmarkable expense if individually or as a group of expenses. It's an expense for which the lender may use statistical information about household expenditure, including utilities, food and groceries, transport, including fuel, WAF, registration, repairs, and vehicle maintenance. So benchmarks may be used as an alternative means of verification. So, I mean, the verification of living expenses is not always straightforward based on bank statements. And the use of benchmarks can provide a protection against the risk that borrowers may have inadvertently underestimated their expenses. So lenders who choose to use benchmarks for the verification stage must use the higher of the benchmark or the initial estimate. So the Commission won't be developing or publishing benchmark expenses for use by lenders. Lenders can develop their own benchmarks or use benchmark expenses developed by others, provided that statistical information meets the requirements set out in the regulations. So we'll look to place in the chat the regulation which sets out the minimum requirements for a benchmark.
Yeah, absolutely. Penny will pop that in there. Hey, so Mark, there's a question here which says, would a customer's previous purchase or payment history be a valid method when considering affordability? What do you think?
I mean, the regulations don't mention payment history as part of the assessment process per se, but the regulations only send out the minimum inquiries and assessments. So previous payment history, if relied upon, can at times sort of mask genuine affordability. So accordingly, we would say that a lender can consider payment history as part of their affordability assessment, so long as this is an addition to and not a substitution for the assessments required under the regulations. So, I mean, when approving a loan, what lenders can't do is put a borrower in a position where they experience substantial hardship. So the affordability assessment must ensure the borrower can meet their current financial commitments without difficulty and their new loan obligations.
Of course.
So, and this will ensure that borrowers do not prioritise loan repayments and then fail to meet other commitments.
Yeah, absolutely. Hey, there's an interesting question here about revolving credit. So it says, what are the Commission's expectations with regards to lenders verifying revolving credit and overdraft or credit card limits?
The regulation set out specific rules about how a lender must determine the estimate of likely relevant expenses for payments under revolving credit contracts that have credit limits. So again, we'll look to place that in the chat. And I suppose where verification of the credit limit is not reasonably practicable, we would expect that lenders could rely on what the borrower has told them about the credit limit, unless the lender had any reason to believe that the limit advised wasn't accurate.
Yeah, that makes sense. Hey, so here's another one that I think could be relevant here. If the lender can't verify the estimate against reliable evidence, what does the Commission view as an acceptable alternative?
I suppose in terms of expenses, Regulation 4A provides for two alternatives to verification by reliable evidence. One is use of benchmark expenses, which was touched upon, so using the higher of the initial estimate or the appropriate benchmark. And if neither verification by reliable evidence or benchmarks is reasonably practicable, or they don't use benchmarks, the lender can just adjust the expense by estimating a reasonable cost. So that's sort of separate from assessing the reasonable minimum. So benchmarks are obviously the preferred alternative where reliable evidence is not available and should assist in many cases. And I suppose if lenders are verifying otherwise, then they should just keep records about how they've estimated the reasonable costs or amounts. And we would ask that they think about the fact that if lenders are unable to verify how they've assessed a particular amount of income or expense, that might indicate that the loan's not affordable.
Yeah. Hey, so we had lots of questions or concerns about buy now, pay later, like afterpay and lay-by. So do you want to talk to us about that? One of the questions, I think, which kind of sums it up, asks, does the government plan to regulate buy now, pay later, such as afterpay? These pose a considerable risk to affordability, and there's no guidance in the code.
But I think, as most of you probably know, that these buy now, pay later arrangements are not typically consumer credit contracts under the Credit Contracts and Consumer Finance Act. This is because they don't meet the definition in Section 11, because they don't have interest or any credit fees, and nor is there any security interest. So the only fees are default fees, but those are not credit fees for the purposes of the Act. And because buy now, pay later arrangements are not consumer credit contracts, the standard ones, then they're not governed by the responsible lending rules among the other rules. So I think the Commerce and Consumer Affairs Minister, David Clark, announced in June this year that the government's looking at options for regulating buy now, pay later, including potentially bringing it within the Act. And MBIE's looking to issue a discussion paper later this year on possible regulation options. So whether or not buy now, pay later gets regulated by the Act, or gets brought under the Act and regulated by the Commission, that'll be a decision for the Minister and Cabinet, and not for us as
Of
a Commission.
course. Yeah, but great to get that clarity, and good to know that there's thinking and planning happening in the background. Hey, so there's another buy now, pay later question that I think is interesting that we could cover off now. It asks, how should lenders account for regular buy now, pay later purchases? Should they look at what the borrower is paying towards the purchases, or take the full limit into account?
This is quite a tricky question, and we're thinking about what further guidance we might be able to provide on this. But I mean, if the buy now, pay later arrangement constitutes a revolving credit contract as defined by the Act, and it has a credit limit, then lenders will need to calculate the expense in accordance with the regulation for AL2. So a revolving credit contract, I perhaps won't go through the definition. And again, that regulation it's difficult to apply sometimes. But if the buy now, pay later arrangement is not considered a revolving credit contract, then the conservative approach, we would say to lenders, would be to assess the expense on the basis of the full purchase limit had been utilised and that required payments were being made on that, e.g. the full fortnightly instalments. And potentially lenders might be able to tailor their approach based on the borrower's actual use of the facility. For example, if it's a one-off purchase and the outstanding balance has been verified.
Hey, Mark, there's a question here which I think covers off that kind of material change thing that I know we've talked about in other sessions. And I wonder if we could go to that now. The question asks, where a variation to increase a limit is of a minor nature, say less than $1,000, and the repayments remain more or less the same, is it necessary to process a new assessment of bank report data, for example?
I think all increases to credit limits will be caught by the material change definition from 1 December under section 9C3A2. So lenders have an obligation to make the reasonable inquiries to be satisfied that the loan's affordable before making a material change, and not just when the loan is first entered into. So I think, as we mentioned, the material change includes where there's an increase to the credit limit, either by agreement or where the borrower has exercised the power to increase the credit limit. So this means, in effect, that where the credit limit is increased, lenders will need to conduct a new affordability assessment in compliance with the regulations, even where the increase to the limit is modest and the loan repayments remain similar. So I think perhaps now I can talk about a big exception. So the regulations provide that set the general rule that you've got to do this full affordability assessment. However, they do provide an exception for a full affordability assessment when the initial inquiries show it's quote unquote obvious that the borrower will not suffer substantial hardship. Now, the term obvious, that someone can afford something, is a bit subjective, but the code does give some guidance. And what we do know is it's tended to be a really high test. So the code gives an example of someone earning $350,000 a year with net assets over $1 million and just wanting $10,000 credit card for the air points. So so it's potentially, well, we've tried to think as a commission for some other examples that this exception might apply. Again, we think it's a high test, but for example, a $10,000 top up on a $500,000 loan repayable over 20 years, it's very different to a $2,000 top up on a $5,000 loan payable in 12 months. So we would think the exception would probably be limited to situations where the increase is minor compared to the total loan amount, and the records the lender already holds clearly demonstrate that the borrower's income and expenses make the loan affordable. That's another situation in terms of that top up to the home loan. So if this exception doesn't apply, then the usual rules will need to be followed. But I mean, in having said that, and where you are looking at a material change, the lender may not, under the regulations, need to undertake all the same inquiries as when the loan was set up. So for example, when making the initial assessment of relevant expenses, the lender may be able to rely on recent information and reliable information that already hold, and then focus their new inquiries on whether there have been changes to the expenses or income since their last assessment. and that this will then need to be verified, for example, by reviewing recent bank statements and comparing that to those already held. Yeah, so I think that's the sort of the touchstone remains that lenders must have reliable evidence or other suitable means of verification to satisfy that overall the loan, including the variation, is affordable.
Okay, so we've had a few questions come through with regards to people who are working with people who are on benefits. So we've got, so there's some questions come through from mentors saying that they note that benefits and additional supplements to cover essential living costs and additional provable expenses, but there's nothing left over to cover the loan repayments. And then one mentor has specifically asked, what do I do if lenders keep lending to my beneficiary clients? Mark, do you want to talk a little bit about that?
I suppose, I mean, that lenders need to do a full affordable, there's no rule against lending to beneficiaries. So, I mean, but if lenders are going to do that for a new loan, they'll have to do a full affordability assessment. But, you know, I think as mentioned, because beneficiaries are likely to have little, if any, surplus income after payment of essentials, it's, you know, come 1 December, it's probably going to be much harder for lenders to demonstrate that the borrowers, that the loan's actually affordable to the borrower. So I think in terms of if, again, just because lenders are lending to beneficiaries, again, that's not necessarily a problem. But if you've come across instances or multiple instances of lenders lending to people who can't afford it, then that's something the Commission would be interested in hearing about.
And I know we talked in our last session around disclosure and advertising about understanding people's cognitive ability or vulnerabilities that they might have. There's a question that's just come through a lot around that. That same affordability test applies, doesn't it?
Sorry, can you sort of repeat the question?
Oh no, that's fine, Mark. Questions coming through will be answered as we keep going. So Mark, now that so one of the things that I think our mentors will be really keen to hear more about is how they can ask for and receive that affordability assessment. So when a financial mentor requests an affordability assessment on behalf of their client to the lender, what should a financial mentor expect to see?
Well, I think that the records have to be provided for free, and you can expect them within 20 working days. So the record keeping requirements in the Act say that lenders must the records must demonstrate how the lender satisfied itself that the borrower or guarantor could make the payments on the loan or the add-on insurance without suffering substantial hardship. So again, the code provides quite extensive guidance about the records. Again, this isn't the law, but it's guidance about what lenders should keep in terms of the record keeping at paragraphs 5.20 to 5.24. So this is quite lengthy guidance, and we'll just look to put a copy of paragraph 5.20 in the chat. So it goes on, starts at A, and it goes to N. So you can see there's a lot of things that need to be kept.
Yeah, that's great. And just a reminder that the session is recorded and the chat links will be in the session when you're watching it back. Hey, Mark, how should lenders work with borrowers' representatives if there's a disagreement about the outcomes that the representative is seeking for their client? Is there any guidance for this?
Yes, there is. So the revised Responsible Lending Code provides guidance on interactions. So for these interactions, so on page 12, there's a section called Working with Borrowers and Guarantor Representatives. And this provides guidance to lenders when they're working with borrower representatives. So, representatives can be a person acting in their professional capacity, such as a financial mentor or a lawyer or an advocate, or a person in their personal capacity, such as a family member or whānau or friend, a whānau member. So where a borrower or guarantor has requested that the lender work directly with the representative, lenders must do so in good faith. And this includes working constructively and collaboratively with the representative. So in the case of repayment difficulties, this also includes attempting to reach a mutually agreeable solution for both the borrower and guarantor, or borrower or guarantor and the lender. So lenders may refuse to work with the representative if the lender reasonably believes the representative is not acting in the best interest of the borrower, or where the lender has reasonable grounds. For example, that the lender allegedly had acted abusively towards the the representative has acted abusively towards the lender's staff. So where a lender refuses to work with a representative, the lender should provide the borrower with the contact details for a service where the borrower could seek new representation.
Great. Mark, that's absolutely fantastic. Thank you so much. I think we got through a lot of questions there. There are still some in the chat, and we will continue to address those when we pull all of the questions that come through, both in the chat and in the survey afterwards. So Mark, thank you so much. We really appreciate your intelligence and your experience. Hey, so as many of you know, the Commission has created a resource to help with compliance. It's called Red Flags, and many of you have been working with it because it's been around for about 5 years, but we have done a significant refresh of this document for consumer advisors and advocates helping people in debt to help them spot lender behaviour that's unlawful. Now, you will may have received an electronic copy, but if you haven't, you can email us at credit.advocacy@govt.nz. I've missed a bit, haven't I? My apologies. credit.advocacy@comcom.govt.nz, and Penny will pop that email address up in the link. And many of you will know Lizanne, who's going to come and talk with Mark through some of the changes that in the Red Flags document as they apply to responsible lending. Thanks so much, Lizanne. I'll leave you and Mark to talk this through.
Great, thank you, Sonia. Well, thanks, Mark, for that informative session. So a lot of our listeners advise or advocate for borrowers, and they'll be wanting to know what to look out for as they navigate the new rules. As borrowers come to them for help, some red flags may present themselves. There are some common scenarios that seem to crop up, and it would be good to discuss what advisors or advocates could consider if they encounter these things. So, red flag number one. This is probably the most common one. Let's say it's after 1 December and a client presents a debt that a financial mentor knows or has worked out is in a cash flow deficit. And according to their calculations, they know, they think kind of like somehow this person got another loan or credit extended on an existing loan. What should they do?
I mean, the first step is that you can ask lenders for the records of their affordability assessment and any copies of contracts and loan statements. So there are statutory timeframes for the lender responding. So they must provide the affordability assessment, as I mentioned, within 20 working days, and copies of the contracts and statements within 15 working days. So, I mean, the requirement to keep records comes into force from 1 December, although we'd hope lenders had records before then, but the actual strict requirement to keep records comes into force from 1 December, and this applies to new loans and top-ups after that date. So if you're asking for the records on a top-up, just note that it doesn't have to include the original assessment on the original loan. It would be a lender's choice about whether to provide that or not. And when you're comparing your assessment with the lender's assessment, just have a look at the glossary or in the regulations around the defined terms, just so you know you're comparing apples with apples. So, for example, if you might think that income shouldn't include tax credits or benefit supplements, and you look at the definition of income in the regulations, which suggests it can be included. So, we'll put a definition of income in the chat as well. So likewise with expenses or listed outgoings, as we mentioned earlier, these are defined in the regulations. So lenders don't have to account for every single expense, only the ones that fit into the categories that are defined as listed outgoings. So on that note, with a benefit supplement being provided for a specific expense, the corresponding expense should show up in the applicant's bank statements. So, I mean, if you think your client shouldn't have been given a loan, you can complain to the lender, and they should take your complaint seriously. You should provide some supporting information or the reasons why you think they haven't met the standards the law requires. And it's a good idea to provide some information about what happened to your client after they got the loan, i.e. any substantial hardship they might have experienced. But be clear about the outcome you want to see. And if there's any dispute over the issues about whether you believe there's a suitable outcome given the circumstances and the evidence you provided, the next step is to make a complaint to the lender's dispute resolution scheme. So they can then investigate on behalf of your client and seek a sort of independent resolution. And any order that they make is binding on the lender, meaning that the lender must comply. And you should also let us as a commission know about, from a public perspective. So, I mean, if the problem is more than a one-off, it could be because of the lender systems or processes and happening on a wider scale, we definitely want to know about that.
Thanks, Mark. Just also a note, we've got a glossary of all those terms in the back of the red flags. Mark, another red flag that comes up regularly is a client having repayment difficulties because of foreseen circumstances at the time they entered into the loan. For example, they've just had the baby that they were pregnant with when the application was made, or they were on a 3-month trial period with an employer and now they don't have a job. What do you think?
Yeah, so I mean, there's an express requirement in the regulations to ask the borrower about any likely changes in their income. So, this is a question that comes up with lenders as well. So they're definitely thinking about this sort of stuff. I mean, the loan approval process, I mean, is about working things through with the borrower, as potential issues come to light. So if the lender failed to ask that question, or perhaps omitted to properly assess the information that was provided at the time, and the borrower experienced substantial hardship, you could complain to the lender. Actually, yes. So I mean, even if the borrower the borrowers don't necessarily have to incur substantial hardship for there to be a breach, but it's just because it's all about the assessment made at the time. But still, the substantial hardship often is the thing which triggers the complaint. And again, you can request the records from lenders, and they should show the inquiries that they've made and the information that they gathered to make the assessment that they did.
Thank you. We've got one last one, and it's about suitability. And in fact, we had a question about this earlier on about retailers. In this particular case, a client wants to borrow a certain amount, or they just required a certain amount, for example, to buy a particular good. But the lender extended more credit than what was required. And a common scenario is in a retail situation where the borrower has sought to, say, buy a couch, for instance, that costs $2,000. And then they were set up on a credit card facility and they were extended $6,000 worth of credit. What should a mentor do in that situation?
I mean, I said a few times already that they're tricky questions, and this is another one which I think is quite tricky. So the lender must make reasonable inquiries about the purpose of the loan. So this includes asking the borrower about how much they want to borrow. So I mean, you can ask for the lender's records, which must include their assessment for suitability. So, and as mentioned earlier, so suitability is about matching the right for finance product to the borrower's requirements and objectives. It doesn't have to be the very best product, but it has to be an appropriate, adequate product for their requirements and objectives. So the lender's record should record the amount requested or needed to complete their purchase, and if more was loaned. And they should really keep a reasonable explanation as to why, as to why they lent the amount that they did. So, and if you consider the reason to be unsatisfactory or the amount extended was not suitable for your client, for example, the store person simply asked if they wanted more credit and they said yes, and there was no actual requirement or objective for that additional credit, then it's possible that it could breach the suitability rules, and then you could complain to the lender.
Great, thank you, Mark. Well, that's it for the red flags. I'll now pass you back to Sonia, who will just take you through some live Q&A. Thank you, Sonia.
Yeah, so there's a really good question here, Mark, that I think people would like to have answered, which is, what if we have an application from an overstayer whose visa has expired?
I mean, the regulations and responsible lending principles do not apply differently, as such. Although in this case, we would expect the lender would have difficulty satisfying itself as to the stability of the borrower's likely income over the relevant period.
Yeah, that makes sense. Okay, what about this one? Will the Commission be doing checks and audits of lenders' systems? Excuse me. Will the Commission be doing checks and audits of lenders' systems, policies, and practices, and approving them in any way?
I mean, the first up, the Commission doesn't do audits. We don't approve things or sign off on any individual lenders' policies or processes. So it's up to lenders themselves to determine or ensure that they're complying with the obligation. I think over the next year, we are intending to do increased amounts of lender outreach. So basically meeting with lenders one-on-one and giving them more material, sort of educational materials, and hearing from them where they're facing problems. So I mean, I think in addition to our education efforts, we also undertake investigations into lenders to assess their compliance with the responsible lending principles, typically as a result of complaints received, often from financial mentors. And sometimes we can use our monitoring powers to understand compliance across a whole sector, for example, high cost lending or mobile traders. So I think one thing to think about if you're a consumer advisor and you're dealing with lenders, so your complaints should be taken seriously, regardless of the interaction the Commission may have had with the lender. So we don't audit or approve a lender system. So if a lender comes along and says, oh, the Commission's audited our systems or processes, we're all fine, you know, that's not true.
Yeah, it's good. It's good to get that clarification, Mark. Thank you so much. Hey, so I think that's all we've got time for today. I'm conscious of everyone's time and we want to make sure that we don't go over too much. So Mark, thank you so much for everything that you've provided us with today. We've covered a lot of information and it's a lot to take in over Zoom. I just want to reiterate, we are recording this and it'll be available to people. But in the meantime, Mark, is there anything else that you'd like to add?
No, I think that's it from me.
Great, thanks, Mark. And thanks to all of you for watching and listening to this webinar. I hope it's given you a deeper understanding of the law changes around responsible lending. So as we have in the previous survey sessions, we're running a survey at the end, and you can let us know what we've missed or what areas you'd like more details around. And again, if you can't access that survey, you can just email us at any time. We'd love to hear from you. So when this window closes, you'll be invited to click continue to go through to the survey. And if that doesn't work for you, you can always email us, and Penny's just popped it in the chat, credit.advocacy@comcom.govt.nz. So there's one more session today. Our colleagues at the dispute resolution schemes are running a really interesting session on making complaints. So if you want to make sure that you've got the link for that and you can't find it in your inbox, then flick us an email. And then on Thursday, we have our final in-depth session, which covers off certification and a couple of other areas. So kia ora koutou for your great listening skills. Thank you very much. And I'll close as we started with karakia. Unuhia, unuhia, unuhia ki te uru tapanui, kia wātia, kia mama te nāko, te tiana te wairo e te ara tangata, koe rā e rongo, whakaere ake ke runga, kia tine, tēnei hue, tai kia. Haere rā.